A very important judgment has been passed by the Honourable Supreme Court on the 4th of August 2025, and this judgment relates to the powers of the pollution control boards to impose penalty and compensation. The Honourable Supreme Court has of course held that the boards are empowered, but in doing so it has held that basically there are two categories of violations. One violation is a violation of a statutory provision where a provision of imprisonment and fine is provided, as in sections 43, 44 of the Water Act and the Air Act. The Honourable Supreme Court says that in terms of violation to statutory provisions, the boards are not empowered to execute punitive provisions. These have to be strictly as per law after cognizance by the courts, and of course as per the procedures laid down in the Jan Vishwas Act. The Honourable Supreme Court has also held that the boards cannot impose penalty for every contravention. So when it comes to non-compliance of statutory provisions, the boards cannot impose any penalty. They have to work strictly as per law according to provisions of, as the Supreme Court says, Chapter 7 of the Water Act and Chapter 6 of the Air Act. The second type of contravention that the Honourable Supreme Court has noted is that compensation can be charged for restitution of environmental damage. So it recognizes the second category of default as damage to the environment, and for damage to the environment it says that the compensation can be charged. Now the Supreme Court says that the pollution control boards have got the powers under section 31A of the Air Act and 33A of the Water Act to impose environmental compensation because of damage. But this has to be done only after a proper damage assessment. And the Supreme Court has also said that to enforce this, there have to be procedures and guidelines which have to be finalized through subordinate legislation. So the enforcement of the orders of the Honourable Supreme Court as passed on the 4th of August 2025, they are possible only after the procedures and guidelines are finalized through subordinate legislation. And second is that the Supreme Court has also referred to the guidelines prescribed by the CPCB for assessment of penalty and compensation, and it has directed that these guidelines have to be reviewed and they have to be reissued by a subsequent notification. So in summary, the Honourable Supreme Court regards two types of violations. One is a violation for non-compliance of provisions of law for which punitive provisions are there, and these punitive provisions can be exercised only as per the Air and Water Acts and the Jan Vishwas Act amendments. So far, the second category that the Supreme Court has said is the compensation because of damage. Now, this can be enforced by the state pollution control boards under section 31A and 33A, but it has to be done after a proper damage assessment, and the entire thing has to be enforced only after the procedures and guidelines have been finalized through a subordinate legislation. So this is, I thought I should like to share with you my interpretation of the Honourable Supreme Court's order. The boards, I think, as per the Supreme Court order, can now issue directions for compensation for restitution of damage only, and not for violations like somebody does not have a consent, then you don't do that. You don't levy environmental compensation. There it is a procedural lapse, and for a procedural lapse you will have to follow the procedure of law, the Jan Vishwas Act, the adjudicating officers, etc. That's all. Thank you.